So our final topic today is protecting your trade secrets. We have David Wiley, who is a partner at Baker Botts. He has a broad intellectual property and technology practice, focusing on intellectual property litigation and appellate work. He also has substantial experience in licensing related to patents, trade secrets, software, and copyrights. In addition, he handles secured transactions and mergers and acquisitions involving intellectual property. David also helps clients develop policies and procedures relating to the internet, including website usage agreements, and has handled a variety of internet issues for several Fortune 500 companies. David is currently an adjunct professor at the University of Texas School of Law, where he teaches basic patent law, advanced patent law, and intellectual property licensing. He is also the named inventor on 4 patents. And we also have David Tobin, who's a senior associate at Baker Botts. David is in the intellectual property group at Baker Botts with an emphasis on patent litigation and represents a wide variety of clients, including telecommunications hardware and standards, computer hardware and software, e-commerce, data compression, semiconductor manufacturing and design, fossil energy, medical devices, chemical, pharmaceutical. He pretty much hits all the different industries. He also has a transactional experience, including negotiating licensing agreements, advising clients on intellectual property acquisitions, and conducting due diligence. David's pro bono docket includes representing veterans before the U.S. Court of Appeals for Veterans Claims and representing juveniles and asylum seekers in immigration court. He has also first chaired a number of bench trials and jury trials on pro bono matters. So I will hand it over to David and David. Thank you.
Thank you. Good afternoon. Last year at this time, David and I were in Houston in the middle of the COVID crisis and in the middle of a 3-week trial. One of the few trials of that length to occur in Texas at the time, and it was a live trial. That could be a talk in and of itself, how to do a 3-week trial in the middle of COVID. But it was a trade secret trial. We represented a company called Dril-Quip, and the plaintiff was a company called FMC. And I'm going to begin by giving you some of the alleged facts that FMC talked about in its opening statement and its closing argument. And I'm using their language as closely as possible. Obviously, I'm compressing it because it was a pretty complicated case. I think it was 45-minute to an hour opening. So I'm compressing it, but I want to give you an idea of the case. So Rick Murphy spent many years as an engineer at FMC. Mr. Murphy was not happy at FMC in 2019, and he began secretly talking to Dril-Quip about what they could do for each other. Mr. Murphy wrote a resume just for Dril-Quip, and on May 13th, 2019, Mr. Murphy emailed a confidential patent application to Dril-Quip's Director of Technology a week before he left the company. 7 days later, Mr. Murphy gets a job offer from Dril-Quip. Dril-Quip does not interview anyone else for that position. They only interview Mr. Murphy. Mr. Murphy creates a spreadsheet to calculate how good this job is going to be. He calculated that he'd make about $50,000 more a year and almost $700,000 more over the next several years. So what happens next? The day he has the offer, he begins to secretly use a flash drive to download confidential design documents, drawings, programs, you name it. And he does that knowing he is going to Dril-Quip. FMC did a forensic investigation and figured out that files had been copied. What happened to that drive? Mr. Murphy said he realized it was wrong to do something like that, and he destroyed it. And yet these files show up on his computer after he left work to go to Dril-Quip. In fact, he plugged that flash drive into his computer on May 27th, a week after he left FMC, to his personal computer. The day he leaves FMC, he signs a written acknowledgement. The acknowledgement confirms that he was provided confidential and trade secret information and that he agreed to keep it confidential and not disclose it to any unauthorized person or use it to compete. The acknowledgement says he's required to return all company information and data to the company, and that removal or destruction of company information is strictly prohibited. The acknowledgement also says that he has delivered to the company all copies of any documents, writings in every form whatsoever. On June 12th, he emails himself a PowerPoint that has slides taken directly from FMC PowerPoint drawings. On June 25th, he emails himself an FMC design drawing and accesses it. On July 12th, he creates a drawing for Dril-Quip that is built out of an FMC CAD drawing. Okay, I'm going to stop there. There's another side of the story, of course, but that was part of FMC's alleged facts that they laid out in opening statement. Now, the jury, my personal observation is I think the plaintiff felt pretty good about its case. But the jury found that FMC did not own any trade secrets after several days of deliberation. Now, we presented multiple theories at trial as to why FMC did not own any valid trade secrets, and failure to take reasonable measures was one of them. So here's the point. I've been on both sides. I've tried trade secret cases on both sides of the fence here. And someday you might be involved in a trade secret case, 2 years from now, 3 years from now, 5 years from now. But the outcome of that case could be dependent upon what your employer is doing today to protect their trade secrets. And we're going to share some thoughts with you today about taking reasonable measures. So let's see here. Okay, there we go. As an overview here, if you talk to people who litigate trade secret cases, some would tell you, well, reasonable measures. You're going to put reasonable measures in front of the jury as a defendant. One judge compared making that argument to the car thief who tries to get off by arguing that the owner invited the crime by leaving his keys in the car. That's one way of looking at it. Another way of looking at it is the judge may have the attitude, or the jury may have the attitude, that if you leave the barn door wide open, you shouldn't be surprised if the horse gets out. So reasonable measures is not an issue in every trade secret case, but it is becoming an issue in more cases. And as you're going to see from some of the judicial opinions that we quote from today, what you do currently and you think may be enough may in fact not be enough. Now, this is a nice follow-on presentation to the last one, and I don't think that was planned, but the last session talked about cybersecurity, and I think a lot of people, when they think about trade secrets, they think about protecting them from being stolen by Russian hackers, like was the discussion in the last session. Well, in fact, the bigger threat to your trade secrets are your employees. Okay, and that's not because they have evil motives necessarily. So Dell did a survey in 2017, and they found that 72% of employees are willing to share sensitive, confidential, or regulated company information. And in most cases, their motives are not malicious. Well, what are they doing? Well, they're trying to do their jobs efficiently, for one thing. So they share confidential information with third parties that they've been told to go do business with. And they do so under the impression that the company, well, they must have a confidentiality agreement with them. My boss told me to go talk to them. Okay, well, they don't always have a confidentiality agreement. Okay, and so that is sometimes how trade secrets get out. But also, how to avoid misunderstandings in relationships, I think, is a good way to sum this up. What the company considers to be confidential and what the employee considers to be just know-how that they've gained, experience they've gained, that they're free to take and use at another company, there's a gray area there where the company may say, oh, that's confidential, you can't use it. And the employee may think that they're perfectly able to use what they learned, that's just my experience. I can take that and use that at the next company. That's not confidential information of the company. That's not a trade secret. And so sometimes you get a trade secret lawsuit because the former employee and the employer have differing views on what exactly is a trade secret and what is not. Okay, so today we're going to talk about we're going to give some reminders about trade secrets and then give some thoughts about reasonable measures. And I'll turn it over to David to talk about some reminders about trade secrets.
Thank you. Hi, good afternoon, everybody. So I'd like to present just an overview and just a few reminders about what trade secrets are. So Texas is one of 48 states, possibly 49 states, that have adopted the Uniform Trade Secrets Act, or in Texas, abbreviated as TUTSA, or TUTSA. It's in the Civil Practice and Remedies Code. And the Civil Practice and Remedies Code defines what a trade secret is. And on this slide, I highlighted two portions. One, a trade secret is all forms and types of information, and then the statute gives many examples, but it concludes with an if. Two requirements need to be met. I'm going to skip the reasonable measures for now because that's going to be the whole focus of the presentation, but one of the elements also is that the information has to derive independent economic value, actual or potential for not being generally known to, and not readily ascertainable, etc. So these are now elements because we're part of the Uniform Trade Secret regime. And again, the definition of trade secret in the statute is very broad. So it includes almost any kind of information. It's not just engineering files or technology or company know-how, but it can also include business trade secrets. In many cases involve things like customer lists or price lists or contract bids. Trade secrets can also include what has been done and failed and what does not work. So to go back a little bit in time, before Texas adopted the Uniform Trade Secret Act, the Texas courts applied the Restatement of Torts and used a 6-factor test to determine what a trade secret is. Importantly, these factors are relevant but not dispositive. And as you see, the reasonable measures is only one of those factors. Other factors include whether the information is known outside of the business, how known it is to employees within the business, skipping 3, the value of information to competitors in the business, the amount of money or effort expended, the ease of difficulty which with others could properly ascertain the information, and then the extent of the measures taken by him to guard the secrecy of the information. Again, this was just one factor out of 6 that the court would balance. But after Texas adopted the Uniform Trade Secret Act, it is now a required element. So the plaintiff, to have a trade secret, must show that the owner of the trade secret has taken reasonable measures under the circumstances to keep the information secret. It is now a required piece of the plaintiff's case in chief and no longer just one factor to be considered among others.
Okay, so we're going to talk about some specific reasonable measures, but one thing I want to emphasize at the beginning is that we're not giving you a checklist, okay? The thing about reasonable measures is that the measures must be reasonable under the circumstances. And because all circumstances are different, there's no checklist that you can take back and implement at your company and say, okay, now we've protected our trade secret because we've checked every box on the list. So different information needs to be treated differently, and different organizations will treat their information differently depending upon their particular circumstances. And so it's a matter of risk management, you know, where you look at the value of the information, the risk of losing that information, and the cost of protection. And the cost of protection is not only the monetary cost, it's how much does it interfere with your employees' ability to do what they do every day. So all of that needs to be taken into account. So just some rules of thumb to think about as we go through the particular areas where reasonable measures should be looked at. Again, I've already covered that every case is unique. So high-value trade secrets, you're going to go into court and you're going to say, hey, this trade secret's worth $100 million or tens of millions of dollars. The jury, the judge, they're going to expect you to expend more effort to protect that information than information of lesser value. And the cost of protecting that information, or your loss of efficiency, that's unlikely to be a good excuse if the information is of really high value with high risk of loss, and it's a big company that's claiming that they own the trade secrets. So big companies are generally held to a higher standard than smaller companies. And, you know, the theory, you know, which is hard to achieve in practice, is that you want to limit disclosure of information to those with a need to know. And that's your ideal goal, but it's not so easy to achieve, as we'll see as we step through this. This is a particular particular case here, and this just elaborates on the need to know. So this is a company that had a shared drive that was only accessible by employees. Okay, so you can't get to this from the outside. Nobody can break into the company and get this. But the person who controlled access to that shared drive generally gave access to it if anybody asked for it. So almost anybody in the company had access to the shared drive. This was one factor among several, but an important one that led to this court concluding that adequate steps had not been taken to protect the trade secrets. So access and need to know applies inside the company as well as outside the company. Okay, so we've kind of divided the reasonable measures into 6 categories. They're here on the screen. And I'm going to start with topic 1, which is identifying and labeling the trade secrets. And so the first thing to consider here is, in addition to this being a risk management process, it's also an intellectual property strategy process. Okay, so what does your company want to protect as a trade secret? Well, that's a question for management, it's a question for legal, it's a question for engineering, it's a question for IT to the extent that IT has to take measures to protect the information, etc. So a top-down process where you decide what type of information to protect as trade secrets will then guide you to the measures you ultimately adopt to protect those trade secrets. And after you decide what you're going to protect as trade secrets, those categories need to be communicated to employees so that employees understand what information you consider to be trade secrets. And they also need to understand what they're supposed to do themselves to try to protect those trade secrets, because everybody who handles trade secrets has some role in protecting their secrecy, and they need to know that. And of course, documents need to be labeled appropriately. What you don't want to have happen is to have this be the testimony from one of your employees.
Okay, and do you know how is the employee supposed to figure out what company confidential information is?
I don't know.
If an employee asks you what company confidential information is, how would you answer the question?
I don't know.
How many think that you could see testimony like that from one of your employees? I suspect every company could see testimony like that from one of your employees. But I have to tell you, if you're the plaintiff, that's not good testimony for your company. People need to understand what the confidential information is, what the trade secrets are, so that they can protect them. So you might say, well, the answer is everything's a trade secret. All our information is confidential. We're going to label everything confidential, and then we're protected. Well, not so fast. Because courts have started to say, well, in this Opus case, they said, you didn't do anything to differentiate your protective measures for the alleged trade secrets from other corporate information. So there's nothing, you didn't show that you did anything to protect this any more than you protected any other information. And the North Star case, the court said, look, general discussions that everything produced by our employees is confidential and general email tags are not sufficient. Okay, so courts are becoming more demanding, and we're going to see this not only with respect to labeling. Okay, that's just one reasonable measure. You're going to see this attitude from courts in other areas as well. If you're going to go into court and claim something as a trade secret, many judges, and I'm not saying every judge thinks the way these two judges thought about this problem, but many judges are starting to demand more from something you say is a trade secret versus just other regular confidential information, if you will. In other words, it kind of reminded me of The Incredibles. Everyone can be super, and when everybody's super, no one will be. Okay? So if everything's a trade secret, nothing is a trade secret, is the attitude of some of these courts. Okay, David?
So as part of the theme of communicating with the employees and avoiding misunderstandings, one of the ways that courts have looked at to accomplish that is through contractual measures. And in fact, courts have been pretty demanding in regards to contractual measures. One court said in the Abrasic case that failure to enter into non-disclosure or confidentiality agreements often dooms trade secret claims. But not just have the contractual measure, but also make the contractual measure, there we go, make the non-disclosure agreement mandatory. So in one case, out of Dallas actually, the employee had worked for years at the company, was never asked to sign a confidentiality agreement. No, they called it a non-competition agreement, but it was not a non-compete. It was just a confidentiality agreement. The employee worked there for 6 years, never asked to sign it. Finally, the company got the good idea to ask the employee to sign it. The employee said no and kept working at the company for a while longer. The employee was accused of taking the trade secrets. And the court faulted the employer because saying, well, you took too long to give the employee the confidentiality agreement, and then you didn't even make it mandatory. So a few things to consider with NDAs with employees is ideally do it as part of the onboarding process when the employee starts with the company. Again, ideally it should discuss what the company considers its trade secret and who owns those trade secrets. Should go without saying, but we've seen it. Not just the employee should sign it, but it should be countersigned by the employer. It should be a binding agreement. Again, if the employment agreement can't be found, it's hard to argue that it exists. So keep copies in the HR file, keep some backup copies to be sure that the onboarding agreements are available. don't just sign it and then forget it till there's a problem, but consider reminding the employee of the agreement periodically. And David will discuss training a little later, but an NDA is not a substitute for training. It's a very good start, but continuous training will also be needed.
Okay, so NDAs with, and actually, I'll just mention, if you're the plaintiff in one of these cases, one of the things that just drives me up the wall when I'm representing a plaintiff is when I say, well, did the employee have an NDA? Oh yeah, they had all our employees have an NDA. Okay, so send it to me. Well, we can't find it. Okay, well, when you can't find the NDA, you have two problems. Number one, you don't have a breach of contract action. Okay? There's no question about reasonable measures in a breach of contract action. That's a question in a trade secrets claim. It's not a question in a breach of contract action. So if the employer can't find the NDA, you've lost a cause of action for breach of contract, which might be easier to prove than your trade secret claim. The other problem with it is the jury starts to say, well, did they really take reasonable measures to protect their trade secrets? They can't even show me that this employee signed an NDA. It may be one of the worst pieces of evidence against the validity of your trade secrets in the case. So just simple, good corporate housekeeping, keeping track of your contracts, keeping it in the personnel file of the employee, and maybe having a backup somewhere if there's a problem with that, very important. Now with third parties, I kind of alluded to this earlier, and we've seen this in litigation too. Beware of global agreements. So a lot of times you have a supplier-customer relationship where the supplier is developing custom equipment or semi-custom equipment for the customer, big systems a lot of times, and there's a global agreement because they do business in a lot of different ways. And so the employees sort of assume, well, there's an NDA in that global agreement, but they never go read the NDA. And the NDA sometimes have terms which do not cover the particular information exchange that's going on. In fact, sometimes that global agreement will say that the information is actually public. We agree any information you give that's not of types A, B, and C is considered public information. And so you then have an exchange. Well, suddenly the thing you're alleging is a trade secret. You may have just destroyed that trade secret because people disclose it without reading the NDA. And then residual knowledge clauses, those are necessary in some cases. So for those of you who are not familiar, that's a clause that basically says, people need to be able to go on with their lives after we have this potential business relationship. So anything they remember in their heads without anything in writing or anything to aid their memory, they're allowed to use that going forward. Well, I've had trade secret cases where, the defendant says, hey, Mr. Smith, he didn't take any documents. They didn't show you took anything. And then, the plaintiff says, Mr. Smith knew this kind of trade secret he could take away in his head. Okay, if the trade secret that he could take away in his head was disclosed to somebody under an NDA with a residual knowledge clause, that could destroy the trade secret because the jury could conclude, well, you gave it to this other party and you said if they could remember it in their head, that was okay.
So let's talk very briefly about physical measures. These are very common among companies, again, to protect the premises from intruders, outside people who don't belong. Companies talk about campus security, visitor agreements and sign-in, no free-ranging visitors around the facilities, badge requirements, no restrictions on photography and recording. And we recently celebrated the 50th anniversary of the famous case where someone hired a helicopter to fly over a manufacturing facility to scope out the trade secrets. The company, the judge said that they weren't required to secure the facilities against helicopters. Nowadays, we have things like drones and telephoto lenses, and the case law is still developing on that. But So physical measures are pretty common to keep bad actors out of the company, but what courts will also look at is the measures taken to help protect the information from employees. So, for example, are badge requirements required to get into one area and then a separate badge requirement for a higher security area that maybe contains the trade secrets? Are employees being tracked if they access the areas of the building with the trade secrets? We've seen the paper bins full of documents. Are those being secured? Are people posting their trade secrets up on glass walls, which we've seen as well, for anyone to walk by and take a surreptitious picture or look at the trade secrets? Or are the trade secrets being locked up and out of sight? Are they being left on the printer for anyone or the nightly staff to collect? Or is there a cleaner workplace and corporate hygiene for that? One also measure we've seen is for the highest value of secrets, consider numbered copies that have to be checked out or checked in. Again, yes, that is tough for efficiency, but that can also show that the company values the information. Courts have also looked at IT measures, again, with preventing outside intrusion. We heard some of this in the last session about hackers, things like firewalls and VPN and monitoring. We've also heard about computer-level security, logins, passwords, encrypted hard drives, two-factor authentication, and the like, but security measures are only as good as the people using them and the people employing them. So on the one side, we have a whole slew of company security measures and firewalls, and on the other corner, we have just the normal employee. Not these Daves, we have that Dave. And so human errors is a weak point in the security, and courts will look at that. So they'll look at many ways for documents to leave the company and how they're being secured. Things like email or a USB drive that falls out of a pocket or gets left at an airport. We've seen examples of hard drives with documents just being left in a truck somewhere. Printers, cloud, social media, the likes. There's many ways for documents to leave the company, and these are all things that as in-house counsel can be considered in how to protect the trade secrets and what kind of policies to enact with these risks in mind. Again, this is not a checklist, but some measures to consider that courts have looked at are password protecting individual files for the types of material the company considers its trade secret. Again, so if the document does get out, its use is limited. Controlling access, monitoring, who accesses the files and what they do with it, limiting access to the sensitive facilities at the company. We've seen some companies actually shut down USB ports on their computers so that their employees cannot access any USB drives. Put in various blockers to block the common social media accounts and common cloud accounts from employee computers. We've seen access control programs that can disable emailing of certain files. And then policies, which can help train the employees as to what is okay and what is not okay. But again, this is one case, and there were many factors at issue when the court was looking at reasonable measures, but one thing that they noted was that there was a hardware book file which had all the company confidential specifications in it, and it was on a shared drive. Employees could download that file and save it to their home computer. And the court noted that it's possible for employees to retain the file on their personal computer indefinitely, and that's what had indeed happened. And the court found that the reasonable measures were not met, and the companies did not have trade secrets. One also thing as a reminder, and David alluded to this earlier, is that again, if it's the kind of measures that protects the newspaper on the coffee table the same way it protects the confidential information of a company, things like badge access and visitor sign-in, courts may view that as a minimum, but for the trade secrets, they may expect more. And the courts will look at what steps did you take for your normal business information, and then what else have you done for your trade secrets. So working from home can present additional challenges beyond the cat eating the document or the kid tugging on the tie, including bring your own device. It's not bring your own drink. But so some companies allow employees to bring their own laptops, smartphones, even little wearables, watches, but also use the access company information from their home computers or at the hotel lobby through some kind of remote access or dial-in. But this also presents risks. In one case out of California, this was another case where the company marked every item confidential and said that all of our materials are our trade secrets. But then the court looked at, if that's the case, what did the company do to protect that information? And noted that employees were allowed to use personal computers to work from home, that no inquiries were made of the employee as to what they did with their personal computers, and in fact, they found 4,500 files from the company on the employee's computer. Turns out only one of them was sent to the defendant, but the court was looking at all of these factors. And the court found that there were not reasonable measures and no trade secrets. Again, this was a worst-case scenario, but employee didn't sign a confidentiality agreement. Employee backed up data to a personal computer. I mean, can, for example, employees stick SD cards in the laptops of your company and be able to back up anything they want? The employee was allowed to take his contact list, his customer list when he left the company, and then the company never asked for it back. So these were a bunch of bad facts for the plaintiff, and the court found that the materials cannot be protected as trade secrets. So again, a few measures to consider for BYOD, which is its own CLE and can be a separate topic, but have policies and consider what devices employees can use. Can they use home computers? If they are, think of how they can segregate their work information from their personal information, and again, how the company can monitor these kinds of activities. David?
Okay, this is a really important one. Policies and training. Everybody knows you should have policies, right? And of course you should have training. But in a trade secret case, these are particularly important. And what I will tell you is that the policies need to have sufficient specificity so that employees understand. As we talked earlier in identifying your trade secrets, employees need to know what a trade secret is and what it's not. This court, the Triton Court, found that, I advanced it here and not there. This court, the Triton Court, found that, well, here we have this employee handbook, we have prohibited conduct, but that didn't identify what a trade secret is. It didn't say what Triton considers to be its trade secrets and confidential information. It was just a vague prohibition about, don't take our trade secrets, don't give our trade secrets to somebody else. So that's not enough, okay? So you can have this nice employee handbook, but if you haven't communicated to your employee what the trade secrets actually are, again, a lot of times courts are not going to say that that's alone is a reasonable measure. Okay, so training is extremely important. Okay, you want to prevent testimony like we heard earlier and like we're going to see here in a few minutes. So make the training mandatory, not optional. Okay, we've seen companies that have all this great training, but it's optional. Okay, well, if it's optional, a lot of employees don't know what to do. That training needs to be a continuous process and not an isolated event. Don't just train them when they join the company. Things change. Rick Murphy had been at FMC for over 20 years before he left and went to Dril-Quip. Well, whatever he was trained on when he came to the company was very different from the environment that he worked in right before he left. So in that training, employees need to be reminded about what categories of information the company considers to be a trade secret, so that they know what's the information I need to make special efforts to protect. They need to understand their role in protecting the trade secrets so that they comply with the policies. So they need to be provided with a copy of those policies, and they need to understand how to follow those policies. And then I would also say, you know, when I'm on the plaintiff side, I love to have records of the content of the training and of the employee attendance. Okay, so suppose the employee's been there 20 years. If I can show the employee had this training every year, and here, you know, here was the content in year 1, here's the content in year 2, I can show what the employee was reminded of over the course of their career. Too many times, companies have document destruction policies. Okay, he's been there 20 years. I can show you the training he had last year. Okay, that's a start, but, you know, what was drummed into the employee for the other 19 years? You know, I'd like to have the content of that training. So training is actually a document. The content of training is actually a document that ought to be preserved for longer. And I guess I want to make this point too, which is there's lots of, there's ISO standards for IT that relate to cybersecurity and other things, but they also go to trade secret protection to a certain extent. So there's model policies out there that you can hire a consultant, they'll come into your company and they'll give you all these policies and write them out. Resist the urge to do that, or if you do, you know, if management says you do have to do that, okay, we're going to do it. You need to tailor them to your business. Because the worst thing for a plaintiff to have is a collection of policies that the employees do not follow. Okay? And what we had in that FMC case was we had a collection of policies, 4, 6, something that we presented with all kinds of hoops the employers were supposed to jump through to protect trade secrets, including inventorying them, using encrypted hard drives, using encrypted email, never taking them home, never taking them out of the company. So then you start deposing engineers and they say, I've never encrypted an email. Why would I encrypt an email internally?
And some of them haven't even seen the policies.
Yeah, and some of them hadn't seen the policies. They were never even given the policies. You know, people took work home. It was a work at home at night and on weekends company, so engineers were taking stuff home all the time. They were violating policies left and right. I lost count of the number of policies we showed that were violated by engineers who were dealing with what they contended were trade secrets. And so if you make policies that look great on paper, but nobody's going to follow them, I think that's worse than not having any policy at all. Okay? So on the plaintiff side, I would much rather have sort of less stringent policies that people actually followed and you can document that people followed them to protect the trade secrets than stringent policies that people don't follow.
Next slide, up there.
Okay, and then, so part of having policies is then making sure people follow the policies. So there has to be at least some effort at monitoring employee compliance with the policies. And if management is violating the policies and not following themselves, it makes it worse. Okay, and then finally the exit interview and procedures related to the exit of an employee. Okay, going back to the beginning, remember the employees are your biggest threat, and the time at which trade secrets leave the company the most with respect to your employees is when they leave the company. So the exit interview is your last chance. Okay, this is your last opportunity to do whatever you can do to prevent your trade secrets from leaving with that employee. They may leave anyway, but you need to make efforts at the time they leave that if this ends up in front of a jury, you can say, look, here's all the things we did at the exit interview. We did all we can do. The person took the information anyway, but we took reasonable efforts. So conduct a meaningful exit interview. And look, this is not like if the janitor leaves the company. This doesn't have to be for every employee. But if it's an employee who has access to trade secrets, which again could be technology, it could be somebody in the C-suite who knows about the merger that's being planned, or knows about, did due diligence on a merger that didn't go through, or something to that effect, financial information, profit margins, et cetera. Anybody who has access to sensitive information. So the first thing to do is ask them where they're going next. Okay, are they going to a competitor? Okay, they might not tell you. They don't have to tell you, but if they tell you, you'll have some information that you can use to make some other decisions. Remind them of their continuing confidentiality obligations after they leave the company. Ideally, provide them with a copy of their confidentiality agreement. Require them to return any trade secret materials, including their devices, their computers, their phones, their flash drives, etc., and any documents that they may have. And then ask them. You'd be surprised how many times we litigate these cases where in the exit interview, the question was not even asked. Do you have any company documents at home? Do you have any documents on your home computer? Did you ever store any files on your home computer or on a personal flash drive or an external hard drive? People don't ask these questions a lot of times. Simple questions. Ask the questions. And then have them sign an acknowledgement of their confidentiality obligations and that they've returned the materials, as well as make them sign their answers to those questions. Okay, so they should fill out, no, I don't have any documents at home. No, I don't have any documents on my personal computer. And warn the employee that, and the new employer in some cases, if this is a direct competitor and look, there's only 3 companies in this space, we know this employee's probably going to go work on something similar over there that he's working on here, then you might send a warning letter to the new employer to tell them, hey, Joe Smith's coming to work for you and had access to a lot of trade secrets while he was here. In this general subject area, we assume you won't assign him to work on similar projects at your place to avoid any risk of trade secret misappropriation. If you have a key employee doing a video or audio recording of the exit interview, maybe something you want to do. If you have a gut feeling that, boy, I got a bad feeling about where this employee's going, what they may do, we may end up in court. Video or audio of that exit interview would be good evidence to have. And then for key employees, preserve their computer and their email for later forensic analysis if needed.
Okay, it says, you are also required to return all company information and data to the company. Required by what?
I don't know.
Okay. So you're not aware of any place where that requirement is documented, fair to say?
I don't know.
Okay.
This is the guy who conducted the exit interview of Rick Murphy. Okay, so he's giving him a document to sign that says you have to return all company confidential information. Earlier, he told you he doesn't know what company confidential information is. Now he's telling you, well, this acknowledgement that Rick Murphy's signing says you're required to return company confidential information. He can't tell you where that requirement is documented. You want your people who are conducting exit interviews to know the company policies, know where they are. If the employee asks questions, they need to be able to explain them to the employee. They should also be asked, people should be asked to return information, not just their hardware, because, okay, so they turned in their computer, but if they have the information on a jump drive, then they still have the information. So here, the court, again, this is a court that found that there were not reasonable measures taken. We cited this case earlier. They weren't asked whether they possessed any of the information at issue or instructed to return or delete the information at their exit interview. And they did get asked to return their equipment, and so what the court said is, well, that highlights that you believe the equipment was valuable, but you didn't have the same view of the information, because you didn't ask them for the information back, you just asked them for their computer back. Okay? Courts are getting more stringent on reasonable measures. Let's return to our friend.
In the standard list of questions, Exhibit D427, that FMC asks employees at an exit interview, is there any question that seeks to determine if the employee has any FMC documents at his or her home?
In Exhibit D427, no.
Okay, and then there's the topic of the forensic examination. So this is a tough call. Now, there is an expense to a forensic examination, but it will not buy you many hours of a lawyer's time in a trade secret lawsuit. Okay, it's just a couple $1,000s to do a forensic examination. So what do you consider when to do a forensic examination, when not to? I generally think, consider the level of the employee in the company. What did they have access to? What did they know? Are they going to a competitor? Do we know they're going to a competitor? Or do we not know anything because they're refusing to answer that question? So it raises some suspicion. What are the types of documents the employee had access to? Is it really important stuff? And is there anything else suspicious about what the employee has done in the weeks or months leading up to their departure from the company? If there's red flags and you're concerned, you should do a forensic examination, and you should do it now when the employee leaves, not wait until a year later, 6 months later, when something else happens and I think this person may have taken trade secrets. You might prevent the trade secret misappropriation if you do the forensic analysis when they leave, and you might be found not to have taken reasonable measures if you waited. Okay, so in other words, if the forensic analysis is done a year later and it reveals that had you done it a year ago, you might have prevented a trade secret theft that has now occurred, that you're saying this employee now misappropriated our trade secrets. A jury or a judge might find that you didn't take reasonable measures to protect your trade secrets because you didn't do the forensic analysis. And I will tell you, in the Dril-Quip case, there was a preliminary injunction hearing early in the case, and one of the first questions the judge asked the plaintiff is, well, when this employee left, did you do a forensic analysis of their hard drive? And that was sua sponte by the judge at the hearing. So judges have gone to school about reasonable measures in trade secret cases, and even the judges are asking the hard questions. So that kind of concludes our talk, and so we'll open it for any questions people may have. No questions? Thank you.